Good afternoon, everybody. This is Paul Godfrey here. I'm an attorney from Florida. This is not investment advice. This is not legal advice. This is for educational purposes, and hopefully you find it entertaining as well. Doing an update on the Kleiman v. Wright case because I noticed after reviewing the docket there had been 2 subsequent complaints after the complaint was filed itself, an amended complaint and a second amended case, I guess not complaints, but subsequent pleadings. So we're going to go ahead and go to those, but before we do that, we're going to go and do a quick refresher on how civil action works. Again, there's some pleadings. You file a complaint as party A, and then somebody responds after you serve them saying, hey, you have to answer, and then they get to file an answer, or they get defaulted, and then you win. If they file an answer instead of being defaulted by the court, then they go ahead and the court says, well, we're going to have a trial eventually, potentially, if you don't settle this on your own. And if there is a trial, I want all the information. I want the facts. I want the truth. I want reality. As I guess a popular expression nowadays is no fake news. Courts don't allow that. Actually, they do, but it's not good when they point out you've perjured yourself. That's actually really not good at all. Fraud on the court's not a good thing. But anyway, so the process whereby a court goes ahead and figures out what actually happens before trial is discovery, disclosures and discovery. And these are devices that parties can use to figure out what actually happened. Again, the 4 big ones being requests for admissions, requests for production, interrogatories, and depositions. Well, there's also subpoenas too, but we're not going to get into the minutia here. Subpoenas can manifest themselves in different ways for documents or persons or testimony, etc. Anyway, so that's where, and then after you get all the facts information, the court says, all right, let's have a trial. And then the trial occurs. So at this point, the Wright v. Kleiman case has been progressing for 1.5 years, and over this 1.5 years, there's been a lot of ongoing discovery and discovery disputes as to what they're entitled to. And part of what happens is if you don't follow these discovery rules, the judge gets upset and says, well, I'm going to do things that potentially may not be good for you if you don't tell the truth, because that's what my job is, to figure out what happened and then to say, based on what happened, this is what the law is and this is what you all have to do. That's what court cases are and what judges do. The law doesn't change, but the facts do for the most part. Well, the law does change, but that's a legislature, and we're not getting into a lecture on, the 3 branches of government right now. So on to the case. Again, notice that there were 2 amended complaints filed. This was the first amended complaint filed in May of 2018, and then there was another one filed at towards the beginning of 2019. Here we go, right here. That's the second amended complaint. So moving on, let's get to those. The first thing you'll notice, here's the amended complaint, and then you can see second amended complaint. So technically the 3rd complaint total, but the second amended one. The first thing that you should notice is that there, instead of being just 2 parties, Ira Kleiman is the representative of the estate of the late Dave Kleiman versus Craig Wright. So that's one, basically the estate and the representative of the estate. He's representing him, so Ira is not his own individual plaintiff here. So this is 1, and then this is 2, Craig Wright. Here you've got 2 plaintiffs, Ira Kleiman as personal representative of the estate of David Kleiman, and W&K Info Defense Research, LLC. So W&K is 1 plaintiff, the estate of Kleiman is the other one, and again, just 1 defendant. So we've got 3 parties now, 2 plaintiffs and 1 defendant. That's the first big change. The next big change is that there have been some additional facts covered. One thing that I thought was really interesting is, a lot of this is very similar. They tweak it a bit, the factual background. The introduction's the same. You got introduction, parties, jurisdiction, venue, that's generally required. So introduction, just a brief background, parties, jurisdiction, and venue. They add some stuff about the whole MRSA because it becomes relevant to the court case later and the fraud allegations. Again, parties, jurisdiction, venue, introduction, factual allegations. The one thing I thought was interesting is after Bitcoin and Bitcoin history, or history of Bitcoin, they go and add Bitcoin forks. So if you've been paying attention to digital assets at all for the past 2 years, or you're aficionado, you know what a fork is in a protocol. The protocol is the method by which digital assets or digital goods or smart contracts, which are potentially digital services, operate. Hashtag digital law, y'all. But anyway, a fork is when the protocol changes, whether the blocks in the blockchain are larger, there's no limit to their size. Potentially they could use, instead of using the 254 SHA secure hashing algorithm, they can do the more updated one, but they have to agree to it in the protocol. And as the protocol gets updated, forks occur if the people don't agree on it. A hard fork is where they never merge back together, and the soft fork is where they change something and it can be re-implemented back into the code. But these were all hard forks, meaning that they're never coming back. So Bitcoin gave birth to Bitcoin Cash. It also gave birth to Bitcoin Gold, Bitcoin Private, Bitcoin Diamond. Bitcoin Cash had its own fork into Bitcoin ABC and Bitcoin SV, Satoshi's vision, who is Bitcoin SV is headed by the defendant here, Craig Wright. Because he has claimed to be Satoshi. Interestingly enough, he claimed to be Satoshi, I believe, if I recall correctly. And then after this came out, as this suit has progressed, he's saying, well, it wasn't just me who was Satoshi. I was the mean Satoshi. The blank starts with an A, ends with a hole. And Dave Kleiman was a nice Satoshi, and I was the mean Satoshi. So there are two of us created it together. I believe, if I recall correctly, I believe that's what he stated. Allegedly. Don't sue me, Mr. Wright, please. I don't have time to defend it. So what's interesting is what they want to do is say they mined 1 million Bitcoin between 2009, 2010, and 2013. Well, any Bitcoin Cash, any Bitcoin Gold, any Bitcoin Private, any Bitcoin Diamond that they own as a result of a fork, so the result of any forks, the individual who owned the original Bitcoin now owns an identical amount of the new type of Bitcoin. So say if they have 1.1 million Bitcoin, they also have 1.1 million Bitcoin Cash, 1.1 million Bitcoin Gold, etc., etc. They've just expanded their cause of action to get more money. So there's also more details on the relationship between the late Kleiman, W&K, the new plaintiff, and then Wright. You can read through the amended complaint if you want. Send a comment to me. I paid for these, but I'll go ahead and email them to you. It doesn't bother me at all. So anyway, they've added more counts. There were 6 counts initially. And now there are a total of, well, the amended complaint added 3 more counts. And they refined one of the counts, the breach of fiduciary duty. So if we go to the breach of fiduciary duty, it was count 4, if I recall correctly. You can see the similarities. They've got the same pictures, etc. So they've amended it. They haven't done substantial changes. There's the pictures of the allegedly forged signature, according to the complaint. We scroll down. We hit the counts. They've also changed the order a bit too. So you have conversion, misappropriation, replevin, which means give me something back, half of the Bitcoin, and potentially now all the other forked Bitcoin as well. Breach of fiduciary duty. Generally speaking, there's 3 types of duty, if I recall. If I'm remembering my business association classes, you have your duty of care, duty of loyalty, and duty of good faith. They each have their own specific requirements. Here, they have switched it around. So unjust enrichment has been moved from count 6 to count 2. Misappropriation has been moved down 1. They've added, here's one, the Federal Defense of Trade Secret Act. That is a federal issue. Specifically, to get into federal court, you either have to address something that's listed in the federal statutes, whether it's a trade secret or copyright or something that the federal government has control over interstate commerce. Otherwise, the states generally, their courts control a lot of stuff. The police powers, as they call it. see going into that. Without going too much and boring you with all the minutia there, I'll probably say that a lot throughout these videos. But in short, that's something that's established by federal statute 18 U.S.C. section, and so accordingly, the federal district court has jurisdiction to hear this case. Don't even have to worry about diversity citizenship. If you want to know more about diversity citizenship, look it up. It's $75,000, different states, but it's their strategy to choosing whether or not you want to file in federal court or state court. But again, won't bore you with all the potential minutia on strategy there. Here, the breach of fiduciary duty, I believe, has been somewhat refined because you still have the breach, but then you also have breach of partnership duties of loyalty and care. That's been added. It's asserted by the estate, so not by the other plaintiff, W&K. So you've got this, but you also have now the breach of partnership duties of loyalty and care. There's different types of business entities, sole proprietorship, partnerships, LLCs, corporations, limited liability partnerships, and a few others. Now they've also added a fraud count, and then they also added constructive fraud too, asserted by both plaintiffs, the estate and W&K. Let's see, fraud, estate and WK, those are both asserting that. And then a permanent injunction right here, basically saying plaintiff requests this court enter injunction ordering defendant to return all bitcoins, forked assets, and intellectual property. I could be wrong because these people are much more well practiced than I. In their own areas. I've been practicing a little longer than Mr. Friedman, but he definitely did a lot better on the bar exam, has handled more high-profile cases than I have. I do more mass litigation quantity as opposed to quality. Anyway, I thought replevin is to give something back, and a permanent injunction means you have to stop doing something permanently as opposed to a temporary restraining order. But, you know, to each their own. I'm sure he's doing just fine. The other thing of note about the second amended complaint is the facts are pretty much identical in the second amended complaint, but they've added one more count. Where is it? Second amended complaint. We scroll down, and it is civil theft. There's something called supplemental jurisdiction. Earlier I mentioned there's a strategy depending on whether or not you can even get into the federal court system as opposed to using the state court system. And then, you know, even if you get into the federal court system, that doesn't mean you're precluded, prevented from bringing state claims. So there's something called supplemental jurisdiction. Say you get into the federal courts as opposed to doing the state courts. Well, any claims that were related based on a pendant and ancillary jurisdiction, we just call it supplemental jurisdiction for short. So basically, it says not only can you bring your federal claims, but for judicial economy, you can also try your state claims in there too. So even though they're in federal court, they're bringing the Florida state Florida statute count. I believe they also did that with the misappropriation. And what's interesting about this is treble damages. So if they're entitled to $500 million from 500,000 Bitcoin, what's that times 3? But $15 billion they're potentially entitled to for civil theft, if not more, based on the forked assets. And then whatever your attorney loves to see on the plaintiff side, attorney's fees. So you get that fee hook. All the work you do, the other party has to pay it. And there's something called the American rule and the English rule. And the American rule doesn't matter if you win or lose. Generally speaking, it's for awards of attorney's fees. Each side has to pay for their own attorneys. And that's meant to, not to. The rule is set in place so that generally you're not hesitant to bring a cause of action, because the English rule, which existed prior, is that if you lose, you pay. So don't lose, because then you have to pay the attorney's fees. Here in America, we thought that, well, we don't want to hinder people bringing lawsuits because they're scared of losing. We want them to bring cases and let them be tried on their merits, not to be scared. There are certain exceptions to that. We call those fee hooks. Get the hook in for those fees, and so that way you can get your money. That way you get paid for the entire action. Again, attorneys love seeing the fee hook, or the fee shift as we call it. Now going back to the, let's see, Here we go. I was going to say going back to the order, but let's do this first. We're right. We'll hit contingency fees in just a second. The order on the discovery. So I'm going to pull out actually my brief summation. I do little outlines here. So again, these are all the same. So the added sections, they added the plaintiff, the estate, and W and K now. Oops, I may have misspelled that there. That's okay. The amended complaint added these. You had the civil theft for the second amended complaint. One of the things that I was going to bring up that I just forgot because I was looking at this outline. Contingency fees. Representing two plaintiffs. So again, they each represent two plaintiffs that they added now. The amended complaint added W and K. So the order, now remember, thank you for being patient and bearing with me. I've regained my train of thought here. The order on the motion to compel discovery, or the contempt order that we went over in the last video. In short, there were 4 findings of fact. There were no findings as to who Satoshi is. They didn't make any findings, and the court said, you know what, I don't even have to look at that right now. They found that there was, in fact, a partnership that existed between W and K. So they established the existence of a partnership between Wright and Kleiman. The court found as a fact, based on the discovery violations and bad faith, as the court said, that the partnership owned intellectual property. They found that there were bitcoins mined. They didn't say the specific amount, but that the partnership did own bitcoins. And then it also found forth that the ownership of the partnership was 50-50 between Dave Kleiman and Craig Wright. So one thing that I think is a little interesting, when you have a lawsuit like this is just where damages are astronomically high, in the billions of dollars, treble damages for civil theft, so $15 billion. It's just a huge sum of money, depending on the value of the other forked assets, potentially $21 billion. You're not going to quibble over millions, but something I wanted to bring up in Florida, and I'm not sure if these are actually rules that are applicable. They probably are in federal court, because there's still Florida attorneys practicing on contingency fees. There's rules. Basically, contingency fee is, you don't have to pay me anything unless I win. And these are ethic rules that state that, if you settle before you get to trial, you get 33%. However, if you have to do more work, you have to go to trial, you have to 40%. If there was a default, or for instance, if they admit it right away and there's less work, it goes back down to 33%. But they're done in price ranges. You can see these price ranges. So if you have 2, you could potentially get more. If you're representing 2 parties and you get 40% for the first million of each party, as opposed to, since there again are both Dave Kleiman and W and K, you get 40% of this first million award and 40% of this first million award. And then between 1 and 2 million, where is it, you get 30%. Between 1 and 2 million, so you get 30% of each, and then 20%. So yeah, if you've had a $10 million case, you'd only get, if you had one plaintiff, you'd get 40% of the first million and 30% of 1 and 2, and then 20% of the remaining $8 million. But if you have 2 plaintiffs and they have to split the damages, that's $5 million a pop, so you get 40% of the first $2 million for the 2 plaintiffs, 30% of 2 through 4 million, and then 20% of the remaining $6 million. So you can see how you'd make a bit more money there. And again, millions of dollars if you're going up to 10 million. That's kind of a big deal. When you're in the billions like this, though, I mean, if you win and you somehow manage to force him to give you those Bitcoin passwords or threaten him with jail somehow, assuming that, I'm not saying he will do this, potentially if he flees or whatever, if you can actually get all that money, I mean, whatever, you can have the extra million. Give me, I'll be fine with mine, 5 billion, whatever. So the other big thing is going back to all of these counts, the 4 things they established. does not mean that they have actually here, since this is the controlling complaint, doesn't mean they've actually established all of the elements of these complaints. So for instance, fraud has 4 parts. There is a material fact, they knew about it, they intentionally misled them. There was reliance on them relying on that material fact, and damages resulted. So again, the 4 things that the court found in the court order was: 1, there was a partnership; 2, that partnership had IP, intellectual property; 3, that partnership owned bitcoins. The amount, not certain, but it owned bitcoins. And 4, that the partnership was basically owned 50-50 by the late Mr. Kleiman and Mr. Wright. So again, they've established parts, maybe A and B of these claims as opposed to A, B, C, and D. So misappropriation, say there's 4 parts to that. 4 elements. You have to prove A, B, C, and D. They may have proved A and B. I'm not going to go over all the specific elements or factors in each of these causes of action. I believe they're all the Federal Defense of Trade Secret Act. There might be factors, but I believe most of these are element tests. I'm not going to go the difference between an element test and a factor test right now. But in short, again, they've not won the war yet, but they've taken some ground by getting those base facts established and having the court say, yes, there was a partnership, yes, it had intellectual property, yes, it had bitcoins, and now potentially, based on the second amended complaint, has forked bitcoins, and so there's potential ownership over Bitcoin Gold, Bitcoin Diamond, Bitcoin Cash, Bitcoin SV, etc. And that ownership and that partnership is split 50-50. So now they just have to prove at this point that somehow Mr. Wright took those assets. So again, war's not won, but the battle's been, a few battles have by the plaintiffs, and they're doing a bang-up job. There's also a part I forgot to mention. There's parts about fraud on the court. It's never good when if you're the defendant and they've got proof that you've committed fraud on the court. There's the counts, but if you go into the factual allegations, and let's see if I can find it. Here we go. Craig attempts to launder the stolen title to WMK's IP by securing consent judgments without serving WK and falsely representing to WMK's consent and using fraudulent contracts. Basically, you're attacking this guy's credibility before he even gets a chance to go on the stand. But throughout the discovery proceedings, Mr. Wright's words speak for himself. If you want to go ahead and read the transcripts or read the court's analysis of those transcripts in that motion to compel. If you want any of these documents, I've got the complaints, I've got the order. If there's anything specifically you want to see, feel free to send me a message. That's it for now. This case will progress. We'll see how it may or may not settle. This is Paul Godfrey again. Thanks for watching. Please like and subscribe if you enjoyed this. Again, if you have any questions, feel free to comment, ask. Let me know. I'll be happy to try to address them. Coming up soon, the Ripple cases, so we can know what's going on there. I am not going to make any assertions as to whether or not it is or is not. I'm going to do a lot of research, whether XRP is or is not a security. I'm going to try to do as much research into it. I briefly went over the 10 counts here today without going into what's required to establish that a party is liable, for instance, something like conversion or fraud, or whether a permanent injunction should be awarded. But I will go most likely in depth and be doing a lot of research, so I won't necessarily be able to put out things this quickly, 1-2 days apart, because it just takes time and effort. You can see these cases last years, so these people are more well practiced than I. I'm just going to try to summarize it. I have the benefit of them having written a lot for me, and I just have to read it and explain it. Thank you so much. I hope you all have a good day, and I don't know, something catchy at the end here. Be well and be kind to each other. Bye.